This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we talk about what happens to a lawyer who attempts or succeeds at insurance fraud by lying to the police, her insurer, and to the State Bar of Montana. Naomi R. Leisz was admitted to the practice of law in the state of Montana in October of 2002, at which time she took the oath required for admission, where Respondent agreed to abide by the rules of professional conduct, the disciplinary rules adopted by the Supreme Court, and the highest standards of honesty, justice, and morality, including but not limited to those outlined in Parts 3 and 4 of Chapter 61, Title 37 of the Montana Code. The Office of Disciplinary Counsel alleged that the respondent ended up pleading guilty to a misdemeanor obstruction of justice in violation of a Montana Penal Code. Respondent was originally charged with felony insurance fraud in violation of Montana Code Section 33-1-1504-1A. Respondent admitted to facts demonstrating the commission of insurance fraud. Respondent filed an insurance claim where she claimed to have swerved to avoid hitting an animal and hit a tree. However, in actuality, her son was driving the car that hit a power pole, which caused damage to both the car and the power pole. Ms. Leisz lied to law enforcement about the accident. She demanded that law enforcement turn over evidence and stop investigating. She also lied to law enforcement regarding her knowledge about the damage to the vehicle and the whereabouts of the vehicle involved in the accident. The insurance company paid the claim. However, when the insurance company learned that Ms. Leisz had not been the driver and the actual facts of the accident, the adjuster indicated the claim would not have been paid had the true information been presented to them. In a case entitled The Matter of Naomi R. Leisz, an attorney at law, the Supreme Court of Montana on February 20, 2025, noted that Ms. Leisz also reported to the Office of Disciplinary Counsel that she had voluntarily transferred her license to an inactive status. The State Bar of Montana, however, had nothing on file which indicated that Ms. Leisz requested her license be placed on inactive status, or that her license was ever placed on inactive status. One should never, in the practice of law, lie to the Supreme Court or to the ODC. Rule 8.4 in Montana states that it is misconduct for a lawyer to violate or attempt to violate the Montana rules of professional conduct, to commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer. In other respects, engage in conduct involving dishonesty, fraud, deceit, or misrepresentation, or engage in conduct that is prejudicial to the administration of justice. Respondent Ms. Leisz conduct outlined above constitutes violations of Rule 8.4, misconduct of the Montana Rules of Professional Conduct. Therefore, the Office of Disciplinary Counsel asked the Supreme Court to 1. Issue a citation to the respondent to which shall be attached a copy of the complaint, requiring the respondent within 21 days after service thereof to file a written answer to the complaint. 2, that a formal hearing be had on the allegations of the complaint before an adjudicatory panel of the Commission. And 3, that the adjudicatory panel of the Commission make a report of its findings and recommendations after a formal hearing to the Montana Supreme Court, and in the event the adjudicatory panel finds the facts warrant disciplinary action and recommends discipline, that the Commission also recommend the nature and extent of appropriate disciplinary action, including an award of costs and expenses incurred in investigating and in prosecuting the matter, and finally, 4, for such other and further relief as is deemed necessary and proper. In my opinion, the Supreme Court should have little difficulty with this referral, nor should the adjudicatory panel of the Commission have any difficulty, since Ms. Leisz not only lied to her insurance company and received insurance benefits based upon false statements, lied to the police about the accident, lied to the ODC and claimed she had placed her license in an inactive status, all of which the ODC alleged were in violation of the rules of professional conduct. In fact, if the local prosecutor had not already allowed her a lesser charge, she should have been and could have been convicted of felony insurance fraud. If the allegations against her were not true, justice would require, if she has a reason that can be explained to the Supreme Court, that she be allowed to keep her license to practice law. Seems difficult, but we will wait for the conclusion of the adjudicatory panel, ordered certainly by the Supreme Court. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. Subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week. You can also receive access to the more than 5,000 blog postings. You can also subscribe to the videos on YouTube and rumble.com. And if you do, they're also free, and I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. Please tell your friends and colleagues about this blog so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.